Article 7, Section 7 of the Texas State Constitution of 1876 stated, "Separate schools shall be provided for the white and colored children, and impartial provision shall be made for both." And while some progress had been made in the courts to end school segregation for children of Mexican and Latin descent, attempts to end the segregation of African American children in Texas had been largely unsuccessful.
There was a sense that the races could not live with one another so closely that there would actually be a dialogue between the races. There was a sense that the races could live together only through peaceful coexistence, that there was a place for African Americans, and that there was a place for whites.
In the early 1900s, the NAACP began filing lawsuits targeting legalized racial segregation. By the mid-1930s, the organization began to concentrate its efforts on ending discrimination in education. Led by Charles H. Houston and Thurgood Marshall, the organization set out to dismantle the separate but equal doctrine established by the Plessy versus Ferguson decision.
And they had a very strong case for attacking it because under Plessy v. Ferguson, remember, segregation was permissible under conditions of equality, separate but equal. In fact, it was almost never equal. And really all you needed to end segregation was not necessarily a ruling that segregation is unconstitutional, but that all this segregation is unconstitutional because the conditions are not equal. So the NAACP began to find plaintiffs and find lawyers and organize and bring cases.
In the mid-1940s, a 33-year-old mail carrier by the name of Heman Marion Sweatt joined the NAACP in Houston. Mr. Sweatt, who had already earned a degree in biology from Wiley College in Marshall, Texas, began to take an interest in the law. This, coupled with his eagerness to help the NAACP fight discrimination, motivated him to apply to the University of Texas Law School in 1946.
He meets with the registrar of the law school, registrar of the university, and they say, "You can't come here. We don't have blacks here. We can help you with out-of-state tuition. We'll send you someplace else. We'll help you there, but you can't get admitted to UT." And he said, "I'm from Texas. I want to practice in Texas. I want to go to UT." They say no.
Having been denied entry to the only state law school simply because of his race, Heman Sweatt, with the help of the NAACP, sued the university's president, Theophilus Painter.
We have to remember that Plessy versus Ferguson was still considered good law, and that called for separate and equal. So while Sweatt was working his way through the court system, the state legislature frantically appropriated a lot of money to set up what were called Negro schools. And one of those schools was a law school that Sweatt could attend, or at least the state officials hoped that Sweatt would attend what was a Negro law school on 13th Street in Austin.
And they were trying to make it equal. You know, they had bought 10,000 books. They had invested, $100,000 in it. They had 3 professors who taught from UT Austin who taught in it, and so they had created a law school. So what's the problem? We're creating a separate but equal law school.
By establishing what they considered a separate but equal law school for African American students, the Texas state legislature felt it had done everything necessary to avoid any further legal action. But Heman Sweatt refused to attend the newly created law school, arguing that it was not and could never be equal to the University of Texas Law School.
Sweatt, if he had attended that law school, would not have had the opportunity to interact with other students who were on the same level, that the law school didn't have a law review. It didn't have the prestige that the University of Texas Law School had. And that basically that the law school, having been created overnight, could not be accredited and on the same level as the University of Texas Law School was.
Look at the resources that the University of Texas had with the top-notch law professors in the nation at that time, and the facilities that were awesome as far as books in the library and other access to other resources.
The NAACP argued that this is separate, but it's not equal. And so this violated even Plessy v. Ferguson's understanding of the Equal Protection Clause.
Heman Sweatt, with the help of the NAACP, continued to challenge the university. And in 1950, the case of Sweatt versus Painter came before the United States Supreme Court.
The main question that the Supreme Court had to answer was the law school equal, and did it fulfill the mandate from Plessy versus Ferguson about being separate and equal? And then the NAACP took it another step in that, was segregation right? And this segregation followed the 14th Amendment.
The strategy of the NAACP was to gradually cut the roots out from under Plessy. So they would go into court and argue, as they did in Sweatt, number one, this is unconstitutional because Plessy's wrong, you should overturn Plessy. Second argument was, even if Plessy is correct, you should seriously apply separate but equal. Separate, yes, but is this equal? That makes the court look at what counts as equal.
One of the first things the Supreme Court does is to say, it's our tradition to decide cases on the narrowest ground. And although there has been some challenge to Plessy versus Ferguson raised by this case, we need not deal with whether or not Plessy should be overruled, because the case really turns on whether or not the black law school is not equal, and we're going to find that it isn't.
The Supreme Court had ruled that under the Equal Protection Clause of the 14th Amendment, Heman, Marion Sweatt, as well as all other eligible African American students, be allowed to enroll at the University of Texas Law School. The unanimous ruling stated that Texas had failed to provide Heman Sweatt with access to a legal education equal to the one he would receive at the University of Texas.
For the first time, the court took this requirement of equality seriously. And if you take that requirement seriously, as I said, that's going to be the end, effectively, of segregation, because the separate facilities were very rarely equal.
The court began by going through all of the tangible factors. The number of professors, the number of books in the library, the quality of the facilities, all the things that you could essentially put a number on. And it demonstrated very clearly that there was no way that one could rationally believe that this new little law school in the basement across from the Capitol was anywhere close to the University of Texas Law School. But then the court took it a step further, and that was really the key. And the court basically said, what's even more important is that it's not equal in terms of what the court called the intangibles. The court said the reason why the University of Texas Law School is a great law school is because it has established a nationwide reputation. It has a network of alumni who have been very successful in the practice of law. It has attracted great authorities on the law. And this is something that has been built up over a period of several decades. So the court said, even if the state were to equalize Texas in the new black law school in terms of all the tangible things, they never could catch up with UT in terms of its traditions and reputation and alumni network. Well, that effectively says that as a practical matter, at least when you're comparing institutions like that, separate can never be equal.
As a result of the ruling, Mr. Sweatt became the first African American to register at the University of Texas Law School. But although this ruling was a victory for African American students seeking graduate degrees, it did not completely end racial segregation in Texas.
The Sweatt versus Painter case obviously was a landmark ruling. It ended the outright exclusion of blacks to a historically and legislatively declared white law school. That was important unto itself. But the question is whether this in any way trickled down to other levels of public education. And sadly, the answer is no.
It was a partial victory insofar as Plessy versus Ferguson was not specifically overruled. And separate but equal was theoretically still possible. But it was a tremendous victory insofar as the Supreme Court had decided to define what was equal in such a restricted way that equality almost became impossible.
Sweatt versus Painter may not have ended racial segregation in Texas, but it was a step in the right direction. Encouraged by the outcome of the case, the NAACP and other civil rights advocates continued to work towards the goals of integrated education and equal protection under the law. And just 4 years after Heman Sweatt brought his case to the highest court in the land, another case involving racial school segregation would come before the court. The landmark case of Brown versus Board of Education of Topeka, Kansas, would be the culmination of years of struggle and sacrifice to end racial segregation in the public school system. The unanimous decision of the Supreme Court would effectively strike down Plessy versus Ferguson by finally establishing that separate can never be equal.